My name is Jennifer Kuyrkendall Griffin. I'm running for Suwannee County Judge. In today's installment of Scales, or Suwannee County Access to Legal Education series, a program I created in 2019, I'm going to be discussing what happens when a loved one dies without a will. So, first of all, what is a will? Well, in simple terms, it's a document prepared by the testator or testatrix to designate who should inherit and who should be the personal representative should a formal administration be necessary. But what if your loved one never had a will drawn up? Now, I've heard people say many times that, oh, the property is going to go to the state. Well, that is possible, but there is a long list of relatives that you have to go through before you get to that point. So today I'm focusing on who inherits in an intestate estate. Other presentations are going to go into more depth about exempt property, homestead property, and how to choose what type of administration is needed for the estate. When somebody dies without a will, it's called an intestate estate. The first question to ask is whether the decedent was married, and we look at Florida Statute 732.102. If the decedent, the person who died, didn't have any descendants or children, then the spouse is going to get everything. If the decedent had descendants, but they are all in common with the surviving spouse, then the spouse is going to get everything. But if the decedent had descendants that are not in common with the surviving spouse, the spouse gets 1/2, and all descendants divide the remaining 1/2. If the decedent was not married at the time of death, we turn to Statute 732.103 called Share of Other Heirs. If the decedent had descendants, the estate goes to them. So if you're looking at a family tree, you first go down. But if there aren't any descendants, you go up to the decedent's father and mother equally. Or if one parent is deceased, it goes to the survivor of the parents. If both parents are deceased, the estate then goes to the decedent's siblings or the descendants of the deceased siblings. If none of those survivors exist, the estate is then divided equally between the decedent's paternal and maternal family, starting with the grandparents or to the survivor of them. If no grandparents, to the uncles and the aunts and the descendants of the deceased uncles and aunts. Or if there's no paternal or maternal kindred, the estate shall go to the other kindred who survive in the order that I just talked about. So what if there's absolutely no family? Well, if the decedent was married, but the spouse had already passed, then the property goes to the kindred of the last deceased spouse of the decedent, as though the deceased spouse had actually survived the decedent and then died intestate. For any case filed after December 31st, 2004, if you get that far down, then it is possible for the property to escheat to the state. But I'll tell you, after reviewing thousands of probate cases as the general magistrate, I have never seen property escheat to the state. So today has been a broad overview of what happens when somebody dies without a will. Next week, I'm going to discuss what happens when somebody dies with a will, which is called testate. If you found this information useful or you know somebody that could benefit from it, please like and share, and definitely follow the campaign's social media. Do you have a particular topic that you would like me to address? Well, send the campaign a message through the social media or the campaign website, and I'd be happy to do a video on the topic. Just remember that I can't talk about a specific case or specific facts, but I can talk in an educational manner. If you miss an installment of Scales, visit the campaign's website to see all of the Scales videos that are available. And remember, on August 23rd, 2022, I'm asking you to vote for me, Jennifer Kuyrkendall Griffin, for Suwannee County Judge.